Welcome to Week 7, Legal Issues and Corrections. We're going to look at the Fifth and 14th Amendment in this video, Chapter 11, specifically due process and inmate discipline. The 14th Amendment protects against state actions that would take away life, liberty, or property, and the Fifth Amendment protects citizens against federal action that would take away life, liberty, or property. There are two inquiries: whether a person has been deprived of life, liberty, or property, and if there is a deprivation, whether procedural protections were provided that resulted in fundamental fairness. Generally speaking, fairness refers to providing steps to ensure the facts are as claimed by the government. The more serious the loss, the more due process is needed. Inmate discipline, this is one of the most frequently contested and litigated type of actions against inmates. And also, inmate discipline is the most common subject of inmate grievances. Disciplinary action may result in release, being delayed, losing property, losing housing status, losing privileges. The disciplining of inmates is essential for safety and order. Most effective discipline needs to be fair and even-handed. Some would say firm but fair. You need to have a good orientation process, especially one that outlines inmate discipline and their rights and responsibilities in the prison system. Here are examples of some treatment, how you treat others, right to be informed of the rules, the responsibility to know and abide by them, freedom of religion, affiliation, worship, and also the right to recognize and respect the rights of others in those regards, health care, some of these other rights. Responsibilities, not wasting food. You can see that these are kind of the counter side of rights. Visit and correspond with family members. Conduct yourself appropriately during those visits. Right to unrestricted and confidential access to the courts by correspondence. Responsibility to present honestly and fairly petitions. Right to legal counsel, responsibility to use the services honestly and fairly, right to participate in the use of law library reference materials, responsibility to use those resources properly, wide range of reading materials for educational purposes, responsibility to seek and utilize those materials for personal benefit without depriving others. Participate in educational endeavors, training, employment opportunities, responsibilities along those lines. Use funds for commissary, other purchases consistent with security and good order, meeting financial and legal obligations. All staff must be trained in disciplinary procedures, and offense may be committed in the presence of any staff member. Training on inmate discipline starts with the prison's criminal code, a list of offenses inside the prison, and a list of sanctions that may be imposed. Prison disciplinary offenses are of different severities, ranging from the most serious, contraband. The sanctions are imposed based on the severity of the offense. Most serious misconduct is usually reported to parole authorities. Example of other sanctions. Specific procedures for determining whether inmate committed the offense or not, and if yes, which sanctions to impose. Inmate receives written copy. They're brought before the disciplinary authority. Inmate can have a person assist them at a hearing and present their version of what happened. hearing officer or committee examines the evidence, decides whether the inmate should be charged or not. And then if there is a violation, sanctions are imposed. Some jurisdictions allow an appeal. In the area of confidential informants, the Supreme Court has not addressed. The concern is to ensure the fairness of the prison proceeding based on informant evidence necessary to protect against an inmate lying or pointing a finger at another person with whom he wants to get evened. Lower courts have held that hearing officials at a minimum must satisfy themselves with the reliability of the information provided by the informant. Often the discipline authority is required to make a statement in the record that the informant information has been used as evidence, and the authority is satisfied the information is reliable. That reliability can be based on background, the report of the investigative officer, reliability in other situations, corroborative evidence, assessment about the reliability of the inmate informant is done out of the presence of the charged inmate.